Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. I get a lot of questions about amending a complaint. As a matter of right, you can amend your complaint once, but after that right has expired, you need to seek leave from the court to amend the complaint. And there are four tips that I'm going to talk about today that will assist you in convincing the court that it ought to grant your motion for leave to amend. And I'm also going to go over a motion for leave to amend. Okay? So let's get started.
And those tips are conferring in good faith, citing case law, using key words and phrases, and sample leave. Now, most jurisdictions, if not all, require that the party seeking the leave to amend meet and confer in good faith with opposing counsel. In essence, what the plaintiff would be doing by contacting opposing counsel is asking if they would consent to their motion for leave to amend. Now, plaintiff, pro se, you want to always read the local motion rules for the jurisdiction in which the lawsuit is filed. Also, you want to cite that local rule in the actual motion. And we'll see an example of that later on. It's critical that when filing a motion for leave to amend that you cite case law. And for those of you who are not familiar, I want to introduce you to these four cases. Each case addresses amending a complaint and filing a motion for leave to amend a complaint. And notice these are United States cases, which means you can use them in your motion. Now, you may also want to use a case from the circuit in which the lawsuit is filed. And we'll see an example of this later on. Now, pro se, plaintiff, to convince the court in granting you leave to amend your complaint, you want to use key words and phrases that the court itself is familiar with. In Foreman versus Davis, the court stated the following: under Rule 15A, federal courts should freely give leave to amend when justice so requires. And the court mentioned these words and phrases that the plaintiff must show that by bringing the motion for leave to amend, he or she did not act in bad faith. That by bringing the motion, there was no undue delay. That the plaintiff bringing the motion had no dilatory motive. That by granting the leave to amend would not be futile. And that by granting the motion to leave, the opposing party would not be prejudiced. And that no repeated failure to cure deficiencies exist. And what that means, in a nutshell, the court will look at the totality of the circumstances to determine how many amendments is too many to give the plaintiff another chance for leave to amend. So let's look at this motion for leave to amend the complaint. And I'm showing you this to demonstrate the structure of how these motions are presented, and also so that you can see and read for yourself the key words and phrases and how they're put together. Okay? So in this case, of course, we have the title here. Notice immediately the memorandum in support of plaintiff's motion for leave to file amended complaint. They immediately state pursuant to Federal Rules of Civil Procedure 15A. Also, they included the local rules. So you need to read, remember we said, read the local rules. And you want to include the local rules, okay? So let's go down further. So here, the procedural posture, that's another way of saying it's a brief procedural background. You see that here, okay? Then they come to their summary of the argument. Now remember, everyone will present their motion in a different way. They're not going to be exact across the board for attorneys or pro se's. But this is just an example of a structured outline, okay, that you can go by. Again, in the summary of argument, they state Federal Rule of Civil Procedure 15A. They stress that, but they go on and say, contemplates that a court will freely grant leave to file an amended complaint when the interests of justice so require. This is what I call boilerplate language that you, pro se, could use in your motion for leave to amend your complaint. And they continue with this, just a summary. Then they state, defendants will not suffer undue prejudice. Remember, we talked about the key words and phrases? This is one of them. Defendants will not suffer undue prejudice from the filing of plaintiff's amended complaint. And then they state why it will not prejudice the defendants. And you want to do the same. Okay? So let's go down further. Then they get to the statement of facts. Make it succinct. So when you provide your statement of facts, you want to provide facts that are relevant and material to your motion, okay? Next, they have the argument, and this is really the critical part. You want to persuade the court that it should grant your motion for leave to amend. The title here, or subheading, the efficient administration of justice requires that plaintiffs be given leave to file an amended complaint. Heading. That's a powerful subheading, isn't it? It says it all. It lets the court know immediately what you want. It goes on to say, Federal Rule of Civil Procedure 15A, it reiterates, Federal Rules of 15A requires that leave to file an amended complaint be freely given when justice so requires. This standard is readily met here. You want to be confident, and the court wants to hear your confidence, okay? And we move on down. The second subheading is defendants will not suffer substantial prejudice. There we go again with that phrase. There is no other reason plaintiffs should not be given leave to amend. And that's a bold statement. Now you need to convince the court, show the court, give the court evidence, support it with strong, bold, solid statements and case law. So here we go. The United States Supreme Court determined that in the absence, here we go with that, with those phrases, right? And key words, in the absence of undue delay, bad faith, undue prejudice, futility of amendment, etc., the leave sought should be freely given. And there we go. We see Foreman versus Davis, 371 U.S. 178, 182, 1962. And if you go back, we cited that earlier. And notice that this is a U.S. case, right? Well, not only did this movement or this party cite a federal case, but we'll see where they also cited a local case in the Sixth Circuit. This just happens to be a Sixth Circuit case. So it's good not only to cite a U.S. case, and Foreman is one of the four that I listed earlier. This Sixth Circuit case, you want to find a circuit case in the circuit that the lawsuit is pending. The Sixth Circuit applies a balancing test of these factors, which turns on substantial prejudice to the opposing party. You see that? So they're letting the court know that there's no prejudice here. And they say that no such prejudice exists here. You see that? Okay? And then, of course, the conclusion and your signature. And I want to thank plaintiffs in this case for uploading this so that we could use it as an example. I hope that this video has calmed some of you who have anxiety about filing a motion asking the court to grant you leave to amend your complaint, especially those of you who's going before the court for the second time. It may be even the third time. So if you feel like you need to file a motion for leave to amend, file the motion. Keep these tips in mind. Okay? I am Advocate Lucinda, your empowerment lawyer, and we will see you next time. Take care.